So firstly, on behalf of the TUC, I'd like to extend a really warm welcome to anyone joining us in our second series of lunchtime interviews, looking at employment rights after coronavirus. My name's Mary Towers, and I'm an Employment Rights Policy Officer at the TUC. And today I'm delighted to be hosting a conversation with barristers Robin Allen QC and Dee Masters, who will be sharing their insights with us on the impact of coronavirus on the use of technology at work. Robin and Dee are absolute leaders in the rapidly developing field of artificial intelligence and the law, as well as being highly successful and respected employment law barristers at Cloisters Chambers in London. They combine their employment law work as barristers with a legal consultancy on artificial intelligence, offering their expertise on the intersection between artificial intelligence, data protection, and equality issues. Some of you may have come across Dee and Robin's website, which is www.ai-lawhub.com, which is an incredibly useful resource for anyone who's interested in technology at work, the implications for employment rights, and society more broadly. So in short, we feel really privileged that Robin and Dee are sharing their ideas and experience with us today, and we'd like to say a big thank you on behalf of the TUC and the trade unions and workers that we represent. In terms of what everyone joining us can expect from our discussion today, we hope to highlight for you some of the new technologies being used by employers as a result of the health implications of coronavirus and how these might impact on workers' rights, and also some of the ways in which the coronavirus crisis is changing work culture, the consequent increase in the use of technology at work, and how this may impact on worker rights. So thinking about new technologies, first of all, Dee, what are the key trends that we're seeing since the Covid-19 pandemic hit our workplaces?
Thanks, Mary. Well, I think the first point to make is that technology is being used in plenty of really positive ways at the moment. The ability to hold virtual meetings and collaborate on work remotely has meant that some people are able to carry on working and to work really very effectively. Technology is also being used to allow workers to enforce their rights. For example, whilst the employment tribunal system effectively ground to a standstill at the end of March, virtual hearings are now starting to take place with judges and lawyers working remotely. We also know that organisations across the world are looking to technology to limit the spread of coronavirus in the workplace. For example, developers are creating systems which can monitor whether workers are complying with rules, for example, on social distancing. Employers are obviously really interested in those forms of technology because they have legal duties to create safe working environments for their workforce. Yeah. But there is another side. These technologies will concern some. We know, for example, that home workers' productivity and work rate is being monitored via technology. And we know that in an age of social distancing, some employers are relying on new ways of assessing workers, such as deploying facial recognition technology, which will effectively score job applicants alongside a human decision maker, depending on how they behave and how they speak.
And it must be right, mustn't it, that there's a real likelihood that some of these types of technologies will become widespread and perhaps entrenched in the workplace even after the current pandemic has passed?
Absolutely, yes.
So, Robin, could you maybe tell us a bit about the legal implications for workers in relation to these new forms of technology?
Thanks, Mary. Yes, of course. The first point to make right at the outset is that these new technologies will have very significant implications in terms of a whole array of legal rights, ranging from data protection to privacy to equality and to human rights more broadly. If I take one example mentioned by Dee, the use of technology to monitor social distancing, there are obvious privacy implications. Think of it, about the monitoring the movement of workers, and importantly, who they're interacting with, how long and how closely, all that goes directly to privacy. Individuals have a right under Article 8 of the European Convention on Human Rights to respect for their private and family life. And that right does not stop simply because someone is in the workplace. Certainly, there have been plenty of cases in Europe and in the UK which have looked at the extent to which employers are entitled to monitor their workforce and the point at which monitoring becomes so intrusive that it breaches this Article 8. one of our predictions is that Article 8 challenges might well soon be run in the context of Covid-19. Workplace monitoring and health and safety measures will be at the heart of those challenges. We also have to be realistic that it may well be that measuring social distancing in the workplace is simply the thin edge of the wedge. We know, for example, that some startups are claiming to be able to spot sneezing and coughing, as well as whether individuals are actually wearing face masks. Using technology in this way is far more intrusive, and it's not outside the realm of possibilities that employers may consider disciplinary action if workers are deemed to be breaking health and safety rules. This is potentially concerning, as there are still question marks as to how effective technology is at measuring accurately metrics such as how close people are standing and how precisely they are behaving. There are also lesser known legal implications beyond Article 8. I think most of your viewers will already know about the GDPR, the General Data Protection Regulation. But people are rarely aware that the GDPR actually governs the use of algorithms. And of course, algorithms are at the heart of artificial intelligence, of AI. Computers are able to make sophisticated decisions because they're being operated by algorithms which have been trained on data to make human-like judgments. Now, specifically, under Article 21 of the GDPR, workers have a right, in certain circumstances, to object to automated decision-making which relates to them in a personal capacity. Mm. And equally, under Article 22 of the GDPR, a worker cannot be subject to decisions made in consequence of the pure application of an algorithm where there are legal consequences for them or similarly significant repercussions. So it follows that employers who introduce technologies which deploy algorithms to monitor automatically the workforce and to make decisions which impact significantly on them, like decisions around disciplinary action, may well fall foul of Article 22.
And Mary, I think there's another point to make there about the GDPR and Articles 21 and Article 22, because they apply equally to the use of technology to monitor the productivity of workers, something else which I mentioned at the beginning. There have been numerous news reports to the effect that with the increase in home working has come an increase in employer monitoring. For example, employers are logging websites which are being visited, noting the keystrokes being made by employees, and even taking photographs on employee webcams so as to understand whether or not an individual is really at their desk. And this form of management by algorithm has the potential to engage with Articles 21 and Article 22, as well as raising privacy issues. And of course, this isn't new. This form of management by algorithm is something that's been hotly debated in the gig economy for the past year or so, where decisions are often made not by humans, but by apps.
Thanks a lot for those insights, Dee and Robin. And I think I'd add that certainly since the coronavirus lockdown started, many people will have been working from home. And in Germany, there's already a movement towards a post-pandemic legal right to work from home. So I can see that this cultural shift towards working from home may well result in increased use of technology to replace person-to-person management functions, which clearly has some very concerning legal implications. So at this juncture, I'd like to emphasise that, of course, we acknowledge all of those who've been unable to work from home, including this country's key workers who are currently undertaking a huge variety of vital roles in a mass effort of public service, for which we're really grateful. So finally, I'd like to take us on to have a quick look at the use of technology in recruitment practices. So the longer that lockdown goes on, the more that employers are going to have to rely on virtual recruitment. However, with increased home working and the possibility of cycles of lockdown and perhaps a long period of social distancing measures, it may be that the use of technology and artificial intelligence in recruitment becomes more and more widespread. So Dee, it would be great if you could give us some examples of where use of technology, such as FRT, facial recognition technology software, might give rise to discrimination issues. Because I think a lot of people listening might not realise just how discriminatory some of the outcomes of technology-based decisions really are.
Of course. So facial recognition technology, or FRT, is a form of AI technology that focuses on biometric identification. It analyses an individual's face and then compares that data with a known data set in order to reach conclusions. FRT is used in all sorts of contexts which we're very familiar with, like walking through a passport gate, for example. In that context, an algorithm has decided that your face matches the details in your passport. It's worth stressing that this type of facial recognition technology is being used extensively, despite some persuasive evidence that it's less accurate when it comes to analysing female faces, and in particular female faces with darker skin. But importantly, facial recognition technology is now being used in the workplace. It's being used to allow workers to access offices, but it's also being used in the recruitment process as part of, in particular, video interviewing. So some businesses are claiming that sophisticated algorithms are able to determine whether a job applicant would be an ideal employee. And these systems are known to be widely used in America and also to be in use here. That's a problem because many researchers have concluded that using AI in this way can discriminate against, for example, disabled employees, because their disability may mean that they don't fit an algorithm's idea of what an ideal employee looks like. At the moment, there hasn't been any litigation in the UK, but one of the predictions that Robin and I have is that in the future, job applicants who are subjected to these types of processes will bring discrimination claims, probably in the Employment Tribunal, and using the Equality Act.
Mm.
Mary, if I could just add a point or two on this. Algorithms are not just being used to analyse video footage. AI is also being used to assess the way in which people speak. For example, one hiring tool, which we know about, analyses the tone of voice used during job interviews, which again may place disabled people at a disadvantage. Because, of course, if their disability impacts on the way they speak, this will be picked up. And equally, research has shown that some forms of AI have a high inaccuracy rate when it comes to identifying words from people who are Black. The bottom line here is that AI can and does discriminate, and this is a well-known and established fact. The Equality Act applies to AI and algorithms just as much as any other system. It's been used increasingly in the workplace, and yet to date, there's been no comprehensive review of the ways in which AI is being deployed.
Thank you so much for those insights, Dee and Robin. Unfortunately, we're now running out of time. I hope all of our listeners will agree that this has been a really fascinating discussion with Dee and Robin, and a great insight into the world of technology at work and the potential legal issues for workers and unions to be aware of. So although, of course, coronavirus is first and foremost a human health crisis and tragedy, as time moves on from the initial stages, we see more and more of the unexpected and indirect consequences of coronavirus in all aspects of our society. We really hope that in this brief conversation, we've given you all some food for thought as to how the crisis has turbo boosted use of technology at work and what this might mean for workers and the trade unions representing them. So Dee and Robin, thank you again for being so generous with your time and expertise. And with that, I close this lunchtime conversation. Thank you, everyone.